All right, we are now live on YouTube.
You can do the call.
Yep.
The cry.
Just pulling it up. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. We are continuing our virtual oral arguments for our October sitting, thanks to the very good work conducted in the spring by our team led by Joe Stanton and our IT professionals led by Jeff Travers. It has made it possible for us to continue operations without skipping a beat despite the pandemic, and we're greatly appreciative of that. We have 6 cases on the list for argument today. As typical, the first 3 cases are criminal matters. The other 3 are civil matters. We will take a brief recess following the conclusion of the third argument. We will suspend the live stream briefly between each case in order to welcome the other advocates as the cases progress. The first case, I'm sorry, I should introduce our panel. With me on the panel for all 6 cases today are Justice Joseph Ditkoff and Justice Catherine Hand. And as I said, they will be on panel with me for all 6 cases. The first case on our list for hearing is case number 2019 P1385, the Commonwealth versus Hector E. Rijo. You may begin.
Good morning, Your Honor. My name is Richard Hartquist. As you know, I represent the appellant Hector Rijo. Thank you very much for entertaining this argument today. And I will proceed on the assumption that Your Honors are all familiar with the facts in this matter. Going right into my first argument, Your Honor, I was struck in reading the transcript of this on how replete or how compromised each and every charge seemed to be during the course of this trial, having them be just prior to trial, switching the names of victims, and during the trial being reduced either by suggestion of the judge or ultimately by the jury. Counts 1 and 2 involve the allegation that the defendant had proceeded using a brick as a weapon. It was testified before the grand jury that the defendant approached the victim with a brick, brandished it, threatened him, stole his keys. When the testimony was offered by the victim at the time of trial, no such testimony came forth. My argument respectfully is that the Commonwealth knows its victim's story, proceeded with an assault and battery dangerous weapon theory and an armed robbery theory, when we know, and we knew right away at the first day of the trial on the first witness, that a brick wasn't brandished at that time, that a brick was only picked up subsequently.
Mr. Hartquist, I believe Justice Ditkoff has a question for you.
I'm sorry?
Counsel, why does it matter? The Rogers case from the SJC says that it's an armed robbery even if you just use the weapon for your escape from the scene.
I apologize, I did not hear that clearly.
The Rogers case from the SJC says that it's an armed robbery if you just use the weapon to make your escape. So why does it matter whether the brick was used at the beginning or the end?
Well, he actually didn't use the brick to make his escape, Your Honor. What he did was he left the porch and the victim remained on the porch. The victim testified he was scared and didn't know what to do. The brick was brandished as a warning to not call police. So I'd respectfully say that those cases are distinguishable.
Mr. Hartquist, the question I guess I have, I read your argument and I'm trying to understand the remedy that you're seeking, or the defendant did not, if there's a question of the sufficiency of the evidence to support the charges of which the defendant was convicted, then you can certainly raise that as a claim on appeal. If there was no basis for the charge, you could bring a McCarthy motion. But I guess I'm just puzzled by what it is that you're asking us to find in this appeal.
Your Honor, I addressed this case or this argument in terms of prosecutorial overreaching. And there are a plethora of cases in the federal system that illustrate that this is a problem. The defendant's remedy in this case is to have the ability to be charged properly in advance with the facts known to the Commonwealth so that he can attempt to enter a plea. I respectfully argue that if all the charges were reduced prior to trial, the defendant would have had an opportunity to plead this out to the 2 years House of Correction committed sentence rather than a 2.5 to 4 year state sentence. His counsel also has to approach this trial very differently with the added charges. Counsel can't prepare
if the facts were not present to support the charge, then you can bring a motion to challenge the adequacy of the charge, and then you can proceed. I mean, I think it's a little hard. It's always a little hard to guess after the fact at what might have been available by way of a plea. But even if we were to accept that premise, it seems to me you could have gotten to the same place by seeking to adjust the charges based on the evidence that was available at the time of the charge.
That evidence wasn't available to the defense, Your Honor. The evidence available to the defense was the grand jury minutes, which stated that the victim was approached by the defendant with a brick in hand. That wasn't testimony from the victim. That was testimony from the police officer who made the arrest. When we get to trial, the very first witness gets on the stand and testifies, no, he didn't approach me with a brick. He didn't assault me with a brick. He left, he took the keys after grabbing me and he walked away. Now, defense counsel doesn't know those facts are going to come from the victim's mouth, but the Commonwealth does know that those facts are going to come from the victim's mouth. In those same complaints.
How do you know the Commonwealth knew that the victim was going to change their story on the stand?
I think we can only assume that the Commonwealth knew the victim's story. I think we don't know the victim changed his story. We just know that Officer Sandone made a different type of argument or different type of rendition of the story, which was obviously hearsay, which is admissible at the grand jury.
But you're asking us to assume, without a record, that the officer fabricated the element of the facts that he presented at the grand jury, rather than having obtained that from the victim, which is the more logical or the more regular assumption. Now, it's possible that the officer came up with that on his own.
I'm not saying that I'm sorry, Your Honor.
I was just saying, but why should we assume that was the victim's story all along, that it was known to the Commonwealth and the Commonwealth acted in bad faith? I mean, I don't know what the procedure would be, but it seems to me that you would have to create that as a matter of record before you can come here and ask us to supply that missing ingredient to a claim of prosecutorial misconduct.
Your Honor, first, I'd like to argue that I'm not necessarily stating the officer fabricated anything. The officer made a mistake, in my opinion, and it can be interpreted any way we want. But the fact remains, the Commonwealth has access to this victim. The Commonwealth knows this victim's story, and the victim's story came out on the stand. We can't.
It's routine for the testimony at trial to come out in a manner that varies in some respects, some details from what the Commonwealth anticipated. I guess, again, you're asking us to assume that the victim had given a different rendition to the Commonwealth. The Commonwealth acted in bad faith by proceeding on a different basis. I can't rule out the possibility, but I don't see it in the record.
If you can't rule out the possibility on counts 1 and 2, Your Honor, then perhaps we could examine counts 3, 4, 5, 6. In 3 and 4, he's charged with serious bodily injury. Yet we knew from the jump that it was not serious bodily injury as defined. And the injuries were a concussion to one officer and a single staple in the forehead of the other officer. And these aren't life-threatening. These aren't permanent loss of any bodily function or loss of limb. We know in advance of trial that there's no SBI. And again,
at the time of the charging, however, can you say conclusively that the Commonwealth knew what the sequelae of any of the injuries was going to be necessarily?
Well, if I may, Your Honor, go beyond the time of the charging. They certainly knew that by the time of trial that these injuries were completely healed, that they were short-term. They were not contemporaneously existing at the time of trial. The injuries were gone.
Was there discovery about what the status of the injuries was as the litigation went on toward trial?
I don't know the answer to that. I apologize.
No need to, but under those circumstances, assuming that was a knowable fact and would be a significant issue, is there a reason why your client wouldn't have sought to obtain that information and then, as the Chief has suggested, brought a McCarthy motion if it looked like that wasn't going to go forward, if his intent was to obtain better grounding for a plea?
I would imagine that should be done, Your Honor. But again, if counsel doesn't have updated versions, I guess I'm at a disadvantage to answer your question, Your Honor, which I think is an insightful one. What we have is the judge says to the DA at the beginning of day 2, look, you don't have armed robbery against the victim. and the DA reduces it. And he says, look, you don't have serious bodily injury, and the DA reduces it. So the judge was acting as a screener on these charges, but again, we're halfway through trial before this occurs. And the same thing occurs on counts 5 and 6. Those are the leaving the scene charges. Now, leaving the scene of the first accident, Cerullo.
Counsel, what's the rule you're proposing? Are you proposing that whenever the Commonwealth reduces a charge mid-trial, we need to have a mistrial and start the trial over again?
Your Honor, we have 7 charges here. The 6th lead, if I may, the least serious charge was number 7. The 6 charges were altered on the first day of trial and reduced through the course of the trial, not by the jury's verdict. They were reduced by the judge or the DA's volition. And what's happening here is defendants are at a tremendous disadvantage when they go to trial overcharged. The jury's confused. They split the verdict. We end up with compromise verdicts.
Once again, though, if the evidence presented to the grand jury is inadequate to support the charge, the grand jury won't return the charge. If the defendant believes that the evidence is inadequate to support the charge, despite the grand jury's return of that charge, the vehicle that's available is a McCarthy motion. I mean, I don't know. This is a new one on me, and I've been doing this for a while.
I know, Your Honor. It's something that's I felt I've seen in many cases, and I want to bring it to the court's attention. So,
Counsel, the problem is, we have to write an opinion with a rule that lower courts can actually exercise. So I need to know what we would tell superior courts to do if there's a mid-trial, reduction of sentence or a required finding, or if there's 3 of them. I mean, what's the rule that we would tell the superior courts?
If it's clear from the record that the Commonwealth is bringing charges that are either unsupported by the facts or can't be proven, then the charges should be reduced and the defendant should be allowed to both negotiate a plea or try the case on charges that are supported by probable cause.
Don't you think it's a problem that you didn't ask for that in mid-trial?
At mid-trial, Your Honor, I don't think counsel was in a position to do so. I didn't try the case, Your Honor. I'm sorry. At mid-trial, counsel wasn't in a position to do that. Counsel would be in a position to do that prior to trial only.
Why not? Why is it not possible to engage in plea negotiations during the course of the trial?
I suppose
I have some memory that happens from time to time.
It absolutely does. Often what happens in my experience, Your Honor, is that the Commonwealth makes an offer and that offer is on the table until the trial begins. I think that's
if the Commonwealth is proceeding on an aggressive charge and the case dissipates during the course of the trial, again, I have some memory that is often the trigger for an adjustment to the plea negotiation, plea offer.
I can't argue that that's certainly the situation in some cases, Your Honor, but what we're trying to do here is put the defendant on fair grounds prior to the trial beginning. We're also going to save litigation by having clients who aren't overcharged or were able to get a plea bargain which has bargain in it.
So now I'm going to return to the question Justice Zitkoff asked a while ago. You provided a response that expressed the reasons for your concern, but I don't think you provided an answer to his question about what the rule should be.
That's fair, Your Honor. Your Honor, the rule should be that if the facts aren't supported, then that if the charges aren't supported by the facts, such as SBI when we know there's no SBI in advance, or dangerous weapon when we know there's no dangerous weapon in advance.
But here you're assuming that the Commonwealth knew that in advance. Again, we don't know what the Commonwealth knew. We know that the evidence as it developed at trial was different from what was presented to the grand jury.
I'd respectfully disagree with that part, Your Honor, and I may be parsing a little closely for the court's liking, but the Commonwealth should be responsible for knowing the general facts of what their victim's going to testify to and for knowing the law of serious bodily injury. The Commonwealth knows what serious bodily injury is defined as and brings a charge that's over what they can prove.
Counsel, you were answering my earlier question. If the charges aren't supported by the facts, and then you got cut off. So could you finish that?
I apologize. Can I hear that again?
You were saying what the rule was. You said if the charges aren't supported by the facts, and then you got interrupted. So if you could finish, you were telling us what the rule should be.
If the charges aren't supported by the facts, then the charges should be rebrought in a manner that is supported by the facts.
So you dismiss mid-trial but without prejudice?
Or just allow the Commonwealth to modify the charges to ones that they know are supportable.
And what is the trigger for that to occur?
That's a great question, Your Honor. And I asked myself that prior to this argument starting, because the case on its face is so obvious in this situation to me that every count was altered and every count was reduced prior to even reaching the jury.
But after the trial began, based on the evidence as it was presented at trial, I mean, I guess, are you suggesting that that it is incumbent on the Commonwealth to do that, or incumbent on the judge, or incumbent on the defendant to bring a motion?
Well, I've hosted, I've brought in a lot of case law that shows that the Commonwealth is responsible for making sure they can support their charges. So the burden's on the Commonwealth, but I suppose that the motion would have to be made by either the judge or defense counsel by the time where the ball's rolling.
Right, and that didn't that sounds to me to put us back on more familiar ground. That sounds like a process that not only is feasible, but in fact is a process that I think we ordinarily would follow. That trigger did not occur here.
Then perhaps we have ineffective assistance, Your Honor.
Well, it's a little hard to evaluate that on direct appeal. I don't know exactly what better work by counsel would have accomplished, et cetera. So I hear you. I see that you're about to run out of time. You have several other arguments in your brief, and you can rest on your brief for those.
Your Honor, in my last 15 seconds, I'd like to highlight argument number 3, that the judge specifically defined the car as a dangerous weapon for the jury, did not explain that a car is not dangerous per se, and did not allow the jury to make the decision of whether or not it was a dangerous weapon. Thank you very much, Your Honors.
Thank you. For the Commonwealth?
Morning, Your Honors. May it please the court, Marina Moriarty on behalf of the Commonwealth, and I apologize for the lighting in my office. I'll try to get it right next time. With respect to the defendant's first argument, there is no evidence that the Commonwealth overcharged the defendant, let alone overcharged him in bad faith, or that such a concern is even recognized in the Commonwealth. The reduction of the charges was well within the prosecutor's discretion in this case and inured to the defendant's benefit. With respect to the defendant's claims about the victim's statements, I would simply suggest that the defendant, that the victim in this case, who testified at trial through a Vietnamese interpreter and who spoke to the police at the time of his report, also through a Vietnamese interpreter, it was simply an instance of a victim having a slightly different story, and where that slight difference did make a material impact on the charges that were brought. There's no evidence that the Commonwealth knew that the victim would testify at trial differently than the report that was offered to the police. I would suggest that defense counsel capably impeach the victim with his prior inconsistent statement, noting that he had said something different to the police with respect to the brick, or was it a rock, and whether he brandished it during the taking of the keys or after. I would also note that if the Commonwealth had access to this victim's statement that was inconsistent and did not turn it over, then of course that would be a discovery violation and there would be an issue. However, there's no evidence that that is the case here. And I would also point out that the witness, that the victim is or was equally available to defense counsel or to defense counsel's investigator in this case, and that he or she could have gone out and spoken to the victim in advance of trial to get a firsthand account of the story. I think the judge recognized that this is the kind of thing that quote unquote happens during trials, where the thrust of the testimony is simply different.
What do you say to the argument on the serious bodily injury?
Your Honor, at the time of indictment in this case, I would suggest that a concussion and staples to the forehead were would have supported the substantial bodily injury, that in that if defense counsel had a reasonable belief that they would not have supported that charge, then it would have been appropriate to file a McCarthy motion. a McCarthy motion was never filed in this case, typically because substantial bodily injury is the kind of issue that is generally reserved for a jury. Here, the Commonwealth, in its discretion, chose not to go forward on that prong and reduced that count to ABDW.
And what do you have to say about the judge's instruction on dangerous weapon?
As I noted in my brief, Your Honor, there was no objection at trial, which I think reflects the fact that in this case, given the defendant's, the manner in which the defendant drove that automobile, there was certainly no question that in this case, it was a dangerous weapon. Although a judge should define technical terms where the possibility exists, there would be confusion within the jury. Here, this is not the kind of driving that any reasonable person, and in fact, even the defendant admitted he was driving fast. There's no substantial risk of a miscarriage of justice because in this case, the SUV was driven in such an obviously dangerous manner, and it was conceded essentially by the defendant, and the issue was not whether the SUV was a dangerous weapon, but whether it was driven in a reckless fashion. And so I would suggest that the jury was a discerning group. They did find the defendant not guilty of the armed robbery, and so that suggests that they didn't simply accept everything that was presented to them, that they did give it some due consideration, and that the defendant, that there was just simply no substantial risk of miscarriage of justice with respect to that one particular lack of definition.
Counsel, I'd like to discuss the sufficiency of leaving the scene charge, and specifically, I'm not aware of any case where someone's been convicted or even charged with leaving the scene where the defendant himself did not have a collision. Is there such a case? And if not, why does that fall under the statute? As I understand that the collision is not the later collision, but the earlier collision between the two cruisers that you're charging.
The second collision was directed at. So I off the top of my head, I'm not familiar with a case where the defendant himself didn't collide with the victim's car, but I think certainly in this case, it would have been reasonable for the jury to find that the defendant was aware of the collision. It was not a split second in time. There was some appreciable period of time before the first.
Well, counsel, I think that not enough to just know of a collision. If I'm standing out on my street, or even right now, look out the window and I see a collision, I'm under no duty to report anything. You have to be involved in some way. So why is this enough involvement for the statutory crime?
Well, the testimony, particularly from Detective Sandin, I think, who laid out the series of accidents that were caused by the defendant. I would just note, Your Honor, that there was no causation, was never raised by the defendant in this case.
But you agree, don't you, that to Justice Ditkoff's point, that in order for the defendant to be charged with leaving the scene, the defendant has to have been a cause of the accident?
Absolutely, yes.
Okay. My question is slightly different. You argue in your brief that because of the nature of the impact between the two cruisers, a reasonable fact finder could infer that the defendant would have been aware of the collision by virtue of the sound. But this is not leaving the scene after property damage. This is leaving the scene after causing bodily injury. How do we get to the next step where the defendant is charged with knowledge at the time he leaves, knowledge not only that a collision occurred, but the bodily injury resulted?
First, Your Honor, I'm not sure that that's the defendant's argument on appeal here, but—
That's my question, though.
Of course. To your point, I think the jury instructions, the third element is that, quote, the defendant knowingly collided with or otherwise injured another person. I'm not sure that the defendant needs to know that he injured another person. I do think the defendant needs to know that he collided with another person.
He didn't collide with her.
He didn't collide with her.
Well, I think he collided with a person inside his vehicle, a car that was driven by a person. I don't think if you hit a car that is unoccupied on the side of the road, that is the same. But here it was clear that these police cruisers were being driven, and the defendant was swerving back and forth trying to evade the police stopping him. And so I think in these facts, a reasonable juror could find that he reasonably knew that he caused the accident, which he then fled.
Yes, but the knowledge needs to attach to the. I mean, if we accept the fact that he can be charged based on a collision in which he was not himself involved as a collider, why doesn't he, in order to be charged with leaving the scene after causing bodily injury, need to know that that there was a bodily injury?
I'm not sure that that's what the case law is, Your Honor. I think the case law is that you caused the accident, and that that accident results in bodily injury. I don't think that and that you fail to stop. I don't think that because you leave before the person who caused the accident could otherwise know that there in fact was injury.
I don't know the answer to that either. I'll have to check.
Again, Your Honor, I'm not sure that that's the defendant's argument. Here, the defendant's argument is whether the defendant knowingly collided and whether he was aware of that first accident. And I think...
Counselor, let's assume, for the sake of argument, that Commonwealth versus Muir says the defendant either has to know that he himself collided with a person or has to know that he caused injury to a person. And that's an element of this crime. If that's the case, and I understand you're not sure it is, do you have sufficient evidence, and then why?
I'm sorry, Your Honor. Could you just repeat the first half of that?
I'm
not familiar with that case, frankly.
Yeah, let's assume there's the case, and it says that an element of this crime is that you either knew that you collided with a person, or you knew that you caused injury to a person at the time you went away. If that's so, why do you have sufficient evidence? And I understand you're not agreeing that's so, but.
I think here, the defendant, while he was driving away for a period of time, somewhere less than 10 seconds, would have been aware that between Officer Cerullo swerving around him and crashing into a car and the time when he was forcibly stopped by the tree, he would have known, based on the sound and based on the trajectory of Sergeant Cerullo's car, that he caused an accident resulting in bodily injury.
How would he have known that the accident resulted in bodily injury?
I think a fair inference would be that police cars and the speed at which both cars were driving would naturally result in some sort of bodily and some sort of
perhaps if the airbags don't deploy,
or even if they do deploy, as in this case, and one of the officers ended up with staples, I think was the testimony.
Well, it's certainly possible that they would, but I don't know.
Again, I think that there was an appreciable period of time here where the defendant was aware of the crash and still failed to stop. And I think that is where the judge correctly declined to issue a directed verdict and allow the jury to consider what the defendant's knowledge could infer the defendant's knowledge based on the facts. And if the panel has no further questions, I'm happy to rest on my brief.
Seeing none, thank you both. The case is submitted. We will bring the next.
I'm still curious about where the timer is.
It will appear where Tatiana is. And
okay.
Okay, after I call the case.
All right, we are live and recording.
All right, the next case on our list is case number 2019 P193 of the Commonwealth versus Derek Goen. And I apologize if I've mispronounced the defendant's name.
Good morning, Your Honor. Good morning, panel. My name is Harry Miles, and I represent Mr. Goen. I've heard the name pronounced several different ways in this case. The court is aware from the briefs of what the issues are. Let me talk about Mr. Goen as a person. In this case, we do not have the usual heinousness, I would say, of most of the sexually dangerous persons cases that I think I've dealt with and the court has heard. There was one victim who was the subject of 2 contact offenses, if my memory serves correctly, and there was a number of non-contact offenses involving dissemination of material harmful to minors and violations of various probation orders, which resulted in Mr. Goen's incarceration. The essential problem with this statute, as I presented in my brief, is that it really is so vague and ambiguous on one hand, and so, shall we say, unnecessarily unclear that it makes it very difficult to determine whether a person is truly, an offender is truly sexually dangerous or not. And the Supreme Judicial Court has attempted to speak to that issue on a number of occasions, but I would submit that in fact it failed, and the failure is documented by the Commonwealth's brief. If we go to the Commonwealth's brief, we find that the Commonwealth tries to analogize the serious difficulty concept stated by the Supreme Court of the United States in Crane with the definitions of mental condition, personality disorder, and mental abnormality.
Haven't the Massachusetts courts analogized those concepts?
In Dutiel. They try to, but I would ask the court to consider that an analogy is not an identity.
But in their own interpretation, the Supreme Judicial Court in both Dutiel and Johnstone, not only they recognized the analogy, but they adopted it as adopted the language as the manner of description.
Yes, but if I remember Dutiel correctly, it certainly adopts the analogy. It doesn't adopt language, so that the trial courts.
It recites the language.
Yes, but it doesn't clarify the language. The problem arises, and I'm jumping a little forward faster than I wanted to, but the problem arises because you have a mental abnormality condition to satisfy the elements of the claim. The mental abnormality condition says that a mental abnormality predisposes the offender to commit further sexual offenses. Okay, that's a relatively low bar because predispose simply means a tendency toward. Then when you talk about personality disorder, the language is a general lack of power to control sexual impulses. Now, when you think about that and compare it to the language in which defines mental abnormality, what you're giving the jury is 2 different inconsistent standards, one which is higher than the other, in order to determine whether or not a person, an offender, is in fact a sexually dangerous person. That, of course, jumps me to my next argument, which is that in this particular case, because of the disparity in language and because of the disparity in opinions by the qualified examiners, we don't know what the jury decided. The logical possibilities are that the jury could have credited both qualified examiners. If that were true, then of course, a finding of sexually dangerous persons would not be objectionable on that ground. The jury could have credited one examiner and not the other. If that were true, then the argument disappears.
There was no request. Go ahead.
No, please go ahead.
There was no request for instruction on specific unanimity, was there?
Absolutely, there was not.
Okay.
This is a substantial miscarriage of justice claim.
But the evidence clearly was sufficient for the jury to base the finding on the testimony of either of the QEs.
Well, and there, of course, we get into the third argument, which is, were there two QEs? Was there one QE? The qualifications of a QE are elucidated in Lesage, and by the testimony and reports of both of these QEs, you have, as I conceded in my brief, eminently qualified psychologists, but people who did not comply with the statute, unless the court wants to say that the language of the statute encompasses people who've had experience in psychology, but not necessarily the experience required by the explicit words of the statute.
Would you agree that the Lesage is distinguishable because what the experience was of the clinician in Lesage is very different than what the experience that was testified to in this trial was as to either one of the two QEs. Would you agree with me on that?
Absolutely.
And that here we have QEs who have experience in diagnosis and or treatment of sexually dangerous persons. Would you agree with me on that?
No, I would not.
Okay, and tell me the reason why.
The statute requires diagnosis or treatment. The efforts of a qualified examiner are to assess the sexual dangerousness of an individual at this time. In order to lay a foundation for that opinion, they must have 2 years of experience, not just as psychologists treating sex offenders and persons with paraphilias, but treating sexually aggressive offenders. And those words are taken together, as I pointed out in my brief. And when you take them together, you don't get to any psychologist, no matter how experienced. They could have served on the CAB board for years. They might have done lots and lots of evaluations of sex offenders, but they haven't fit the statute. So I would respectfully disagree with the statement that the statute encompasses that kind of experience.
Counselor, in Lesage, there was a motion in limine to explore the qualifications of the expert, and then a motion to strike after there was testimony. I didn't see either of those in this case, was there?
Absolutely not.
So how can you raise this, and how do you even know they weren't qualified when it wasn't raised at trial?
Well, we have their testimony. We have their CVs that were in evidence. So we take that body of information and we compare it to the statute, and then it's your function, obviously and respectfully, to tell me whether or not the law encompasses the information that you derive from the transcript and from the reports.
In the absence of a challenge, I think Justice Ditkoff's question is, in the absence of a challenge, how do we know that there wasn't more that could have been brought to bear?
Well, we don't. I'm sorry, let me retract that. There's no explicit information of that nature. What we have to do is look at the CVs in evidence and at the testimony in evidence and at the reports in evidence. And from those, one may infer that there's no additional information to be brought forward. I mean, they are voluminous, as you undoubtedly have seen. There's I think Dr. Bell's report is 26 or 28 pages, much of which, first part of which is qualifications, and his CV is all there. So to say that there's more to be brought forward would require me to say, well, what could it be that could be brought forward to explain this that may have been omitted? And I can't think of anything maybe my problem, but I can't think of anything at this point.
That's why we ordinarily expect that those kinds of challenges to be brought forward at the time of trial, rather than leaving us to speculate as to what may or may not have come forward if the challenge had been brought.
I fully understand that, Your Honor, and I understand why the bar is so high when you talk about substantial miscarriage of justice claims. But I would also, if I might point out that at this stage, if the court finds that the qualified examiners were not qualified according to the language of the statute, then of course we have a problem because their evidence should not have been considered and there should have been a directed verdict. The trial court chose not to do that.
Well, no, it wouldn't be a directed verdict because you got at least one of the two was qualified, even by your standard.
I don't believe either. I think Dr. Bell was explicitly said that he had not treated sex offenders. And I believe that Katrin Rousweir made the same statement, although I'm subject to correction on that.
Well, and you're also familiar, the Commonwealth in her brief has given us a fairly extensive inventory of cases in which these two examiners in particular have testified in past cases. It's kind of an extraordinary unpreserved claim seeking to have us find a substantial risk of a miscarriage of justice on the basis of testimony that has been adopted and relied upon in multiple prior reported cases.
I don't mean to sound snippy when I say this. I say it in all seriousness, but to me that's analogous to the upheaval that occurred when we went from Fry to Daubert, and all of a sudden.
Well, again, with all due respect, with Daubert, there is a procedure that you follow before trial. Again, I'm not challenging the possibility that you could make this kind of a claim and pursue it, but to bring it forward on this record and on that history is kind of a heavy lift.
Yes, it is. I understand that, and I'm trying very hard to lift it. And if I fail, I fail.
Thank you. Anything else that you'd like to put before us?
Not unless the court has questions.
May I ask just one question? I wasn't clear from your brief whether you're pressing an argument about the judge's reference in her instructions to menace. Is there an argument that you're making with respect to the use of that term?
No.
Okay, thank you.
You're welcome.
Thank you. We'll hear from the Commonwealth.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. I'll go in reverse order where we're already talking about the issue of the qualified examiners. My recollection is the same as my brother's, that there wasn't a challenge to these very experienced qualified examiners. I disagree with my brother as to that we're at a loss of what could have been offered. My brother is suggesting that the term sexually dangerous person is distinguishable from the definition of QE that includes sexually aggressive individuals. And so what these two qualified examiners could have testified to is their experience with specifically aggressive people. And both of them referenced aggressiveness in their testimony. I'm sure you'll recall Dr. Weir specifically talked about how when someone is aggressive when they're young, as they get older, that aggressiveness diminishes and makes them less likely to be sexually dangerous. So there's plenty that could have been offered to specifically address the claim that the respondent is making here. I would suggest, I know Lesage went the other way in terms of the experience of the qualified examiner, but what I took from Lesage is that it was saying that 2 years of diagnosis or treatment of a sexually dangerous person is sufficient without reference to that phrase, a sexually aggressive individual. And I also cited the unpublished decision in McKinnon for that proposition. And if that's correct, then these two doctors have over 20 years experience, each of them, diagnosing sexually dangerous persons. in addition to that, the trial court judge, if faced with this question, could have looked at the appellate decisions where these two doctors have been found to be qualified examiners since 2009 for Dr. Ware and 2014 for Dr. Bell, and taken that into consideration when determining whether they are indeed experts. So I would suggest in this case, the evidence here shows that they have voluminous experience with sexually dangerous persons, that they described aggressiveness in terms of their discussions of sexually dangerous persons, and they have been qualified examiners for many, many years, which is in their testimony, but also in this court's and the Supreme Judicial Court's case law. So I would suggest that there is no possibility that Dr. Weir and Dr. Bell would have been excluded from testifying. I have made a suggestion to the court. I do not have the legislative history of the statute, but I would note that when the SDP statute was reinstituted, there had been a 10-year hiatus in SDP cases, which I think I cited Bruno for that proposition, which means that there would not necessarily have been qualified examiners with experience in treating or diagnosing sexually dangerous persons in order to effectuate the emergency statute that was being enacted when the new SDP statute came in. Unless there is a question on that, I would, my discussion of that is that shows why the legislature would use sexually aggressive individual as opposed to sexually dangerous person when defining qualified examiner. So if you draw that same inference as me, then you would see there's a reason why the legislature didn't use the exact same words, which makes Lesage make a lot of sense. Unless there are questions on that issue, I'll move to the specific unanimity claim.
On the specific unanimity claim, if the defendant had asked a trial for instruction on specific unanimity, would it have been appropriate under Green?
My answer is no. I think that the respondent is asking this court to change the law. So here we have Green and DiNardo and Chapter 123A, Section 14D. None of them talk about the court requiring the jury to agree on the particular qualified examiner.
As I read Green, it requires the jury to be specifically instructed that they must find credible a qualified examiner.
Yes, and
if we don't know which one, why isn't answering that question in the affirmative consistent with the rationale of Green?
Well, I would state that the instructions did require a unanimous verdict, either for sexually dangerous or not sexually dangerous, and it did require the jury to credit at least one qualified examiner. So it follows Green. I would point to the unpublished decision of this court cited in my brief in Rodriguez, which is the exact same claim that the respondent makes here and was rejected. I acknowledge that it's unpublished. And
well, so unpublished, it also preceded Green.
It did, yes. So I would suggest to the court the reason why, to answer your question more directly, the case law, as the defendant acknowledges, even in criminal law, when he cites Canine, does not require the jury to all agree on the same facts. You could have someone believe one type of Canine factor and another juror agree to a different type of Canine factor, but what it all boils down to is that they all agree that element was met. And that's what would be done here. I have, I apologize, this isn't in my brief. I can also point to Commonwealth versus Santos. It's 440 Mass 281 at page 290. It talks about not needing specific unanimity as to particular theories. So if someone is, alleged creating force on someone else, the jury could believe that they were forceful and constructive force, or they could believe that they were forceful and actual physical force, and yet force element would still be met. And that would be appropriate. And I rely on
different theories of the same element, not discrete elements.
Right. And I would also suggest that if this court disagrees with Rodriguez and disagrees with the analysis the Commonwealth puts forth, in this case, there's no substantial risk. Both QEs were very well experienced. Both of them said there was a mental abnormality. The mental abnormalities that they described are very similar. One's paraphilia and one is pedophilia, I believe. So they're very close in place. I don't think that these instructions here that require a unanimous verdict and require them to rely on at least one QE would raise the possibility that they only relied on one QE, both of them. Yes, there's a question.
Let me ask you this. Green says that the finding of STP has to be based, at least in part, on credible qualified examiner opinion testimony. But the DiNardo instruction that was given here drops the in part and says you have to credit the opinion of at least one qualified examiner. In your view, is the DiNardo opinion too far? Should in part be in that instruction?
I apologize. I hadn't really considered that question, and I think that the in part language would reference the fact that the jury has to also find that there were sufficient convictions. So the qualified examiner alone, while he or she might talk about the prior convictions, I think there has to be proof of the conviction. So that I think that's how I read that language of in part. Because you don't just put forward your qualified examiners, you put forward the prior convictions and the circumstances of those cases can be offered as well, which I think they were here. So that's how I took that. So I apologize if that doesn't answer your question.
No, that's
so because you're concerned about this issue, I would also point to Commonwealth versus Lamb, which I understand was the prior statute for SDP. That's 372 Mass 17 at page 24. It's a 1977 case. And in that case, it pointed out that there was no need for agreement among the experts, that there could be proof with various expert opinions that didn't necessarily agree with each other. And I would suggest that here, where we have the instructions for unanimity, and the jury were properly told that they had to find at least one QE to be credible, what you have here is the respondent asking for an additional element to be placed on the Commonwealth. And I would suggest in the circumstances of this case, there's no substantial risk from not giving the specific unanimity and that he's asking for, and that it was not required in this case. If there are other questions on that issue, I'm happy to answer them, if I can. So I'll just move on to the first issue quickly. In terms of the serious difficulty, I think these instructions actually benefit the respondent, which explains why there's no objection. So that I would suggest there's no substantial risk of a miscarriage of justice by having the federal standard put in there. These instructions ensured that the respondent received the federal minimum standard before he was convicted as a sexually dangerous person under Kansas versus Crane, by including that serious difficulty language. And further, it gave the Massachusetts standard, which is analogous. So I would suggest either one of those standards would be sufficient. The judge gave both in the totality of these instructions. There can be no substantial risk. I am happy to rest on my brief for the remainder of the issues, but I'm also happy to take any further questions.
Seeing none, thank you both.
Thank you.
Admitted. We will return to the waiting room and admit the next pair of attorneys. All right.
All right, we are live and recording.
Thank you. Our next case is case number 2019 P656, the Commonwealth versus Anthony C. Thomas. You may begin.
May it please this honorable court. I'm Dave Humphreys on behalf of Mr. Thomas. bring the matter of his conviction in the court below to appeal. The main issue on appeal is the identification of Mr. Anthony Thomas that was made by the defendant, or rather the victim, the victim in the case, pursuant to a photo array that was created by the police that we are going to argue was impermissibly and unnecessarily, pardon me, suggestive. As part of my record appendix, I have submitted the pictures that were in the array. They are record appendix pages 16, 17, 18, 19, 20, and 21. As I stated in my brief, essentially, I would ask the court to consider that these pictures essentially speak for themselves. Is that when one looks at the photos themselves with regards to my client, there is a physical characteristic of him that singles him out, that causes him to stand out from the other pictures. And that physical characteristic is the length of his beard.
Well, I can tell you, Attorney Humphreys, that Justice Ditkoff's beard was shorter at the beginning of this pandemic than it appears on screen today. These sorts of characteristics have a tendency to vary over time, don't they?
They do indeed.
There was no way that the officers could have known that the photograph that they retrieved from the Registry of Motor Vehicles resembled the defendant's appearance at the time of the encounter, right?
That is true, yes.
We don't know that. I don't know that anyway. If we're certainly the photograph that they had showed a different length of his beard, but we don't know that length matched his appearance as the victim saw it. The police had an undifferentiated reference to facial hair in the information that the victim furnished to them, but it didn't say what type, didn't say what length. It could have been a goatee. It could have been a mustache, could have been sideburns. We don't know. And what we have is a variety of different photographs with a variety of different facial hair presentations.
Right. So I would ask the court to consider is when we talk about the length of his beard in one picture versus at one time versus the possibility that he might have had a different type of facial hair at a different time. What I'm arguing on appeal, and I would ask the court to consider, is the crucial element here is with regards to the lineup, the photos in the lineup, is the length of the beard that he has relative to the other photographs that are in the lineup. And that my argument would be that his beard amongst those pictures stands out. For instance,
were there other photographs available to the police with a comparably long beard?
So I would have to speculate that the answer is yes. I myself have not viewed the database, but it looks like it was a substantial database.
Don't we have testimony from the officers suggesting otherwise?
That's true. One of the things so the question is,
I guess if we're on appeal faced with the choice between speculation and testimony,
right?
Generally we look to the testimony.
So the testimony was that they only had they used one database. There was at least another database that they could have gone to, but they did not. So it's true, yes, Your Honor, is that they looked at one database and the officers testified that they did the best they could. Our argument here is that it was not good enough.
But in order to substantiate that argument, there was an evidentiary hearing on this question, right?
Yes.
Isn't that the point where you can say that they could have done better, but don't you need to show that somehow?
Right. So with regards to the testimony hearing is looking at the ruling in the hearing is that in the ruling that the judge found that there were, she found that there was no physical characteristic that leapt out with regards to him and the length of the beard, that issue having been raised. And while the specific issue of the availability of the other photographs was not argued in that motion, nevertheless, the issues, my argument is that the issues that were raised in that motion were preserved. And they were specifically the length of his beard.
I'm not challenging the fact that the question was preserved. I'm challenging whether the showing was adequate to establish the claim.
Which showing, Your Honor, was that?
That the police could have done better. I mean, surely they can't be faulted for failing to include photographs of long beards if none were available.
So my argument would be is that this is an issue of law, is that it's an issue of law, Your Honor. And my argument would be is that doesn't matter. They have to get them. Is that if we look at these pictures, and previously Your Honor had indicated that there are many different types of facial hair. There's lots of different types of facial hair. My argument is going to be there's not lots of different type of facial hair here. If I look
when you say here, you're saying because of this defendant, but the defendant was in fact a suspect. But if we look at the victim's statement to police, there is nothing inherent in the victim's description that points to this defendant as compared to any of the other photographs included in the array.
Well, that's in the original identification. So in the original identification, Your Honor, all we have is glasses, beard, dark skin.
Right.
And
so the police, on the basis of that description, assemble an array.
Yes. Based on that description, they assemble an array, and we get what I would consider a second identification, which is we go from driving, glasses, beard, dark hair, to this person who we then identify as Anthony C. Thomas. And it's a much, much more detailed description involving a picture. And
yes, that's why you do it.
Yes. And what the basis of my motion then is what gets us there. What gets us there is this lineup where his beard is substantially longer. And the question is, and this is what I would ask the court to consider, is there a physical characteristic of him that singles him out? And again, Your Honor had talked about there's various different types of facial hair and types of beards. On three of these individuals, 17, 18, 19, and 20, so that's four of these individuals, their beard, I believe, could be described as 5 o'clock shadow. There's not much of a beard there. Then number 21, I could describe as it's a type of peach fuzz. So my argument there is going to be in light of the facial hair relative to the other people of the pictures that were presented, it's substantially longer.
Is there anything else that you want to present to us?
If there are no further questions from the court, I do not have anything else to present.
Counselor, do you have Exhibit 2 from the motion to suppress, the statement of the friend?
I'm sorry, Your Honor. Could you repeat that? The volume was low on my end.
Do you have Exhibit 2 from the motion to suppress, the written statement of the friend?
I do, yes.
Could we get a copy of that at your convenience?
If you could file that electronically with the clerk's office, we would appreciate it.
Yes. I'm looking to see if that was part of my record appendix.
It was, I missed it, but I could have.
If you discover that it was part of your record appendix, you can simply send a 16L letter advising us of that fact. But I think I infer from Justice Ditkoff's question that he looked for it and
Very well.
Find it.
I will do that. I will
Okay.
electronically file the statement of the friend.
Okay. Thank you.
Thank you.
For the Commonwealth.
Good morning, Your Honors. Stacey Gauthier for the Commonwealth. Here, the defendant failed to meet his burden by showing, by a preponderance of the evidence, that the ID procedures used by the officers were so impermissibly suggestive as to give rise to a substantial likelihood of misidentification. All the men in the photos were Black men with bald or close-cropped hair, facial hair, and glasses. In other words, they all had reasonably similar characteristics and features. And reasonably similar characteristics and features was found to be acceptable or permissible in Commonwealth versus Burgos, which is cited in my brief, as well as Commonwealth versus Silva Santiago, which was also in my brief. And in Silva Santiago, the defendant in that case was arguing that the photo array was overly suggestive because he was the only person in the photo array who had a fade type haircut. The description of the shooter in that case was said to have short hair, and he was claiming that because he had a fade, that it was overly suggestive, and the court found that that was not the case. And where the victim didn't even describe the type of facial hair, it's not a reasonable inference that a beard was a significant factor in her identification of him.
No, it wasn't, but the officer who assembled the array was aware, of course, that the defendant was the person who was the owner of the van.
Yes, that's true, Your Honor. So there was not a double.
That officer who held that knowledge participated in the presentation of the photo array to the victim.
That's true. There was not a double-blind array. However, a double-blind array is not required under Commonwealth versus Silva Santiago. That would go to the weight of the evidence and not its admissibility.
I understand, but if we're talking about the sort of putting the thumb on the scale, if you will, there is a somewhat greater potential when the officer who knows which of these photographs depicts the owner of the van that was involved recognizes that there is some difference in physical appearance. And then participates directly in the presentation of the photographs to the victim. There is a little bit more concern than there might be, either if it was double blind or if someone else had assembled the array.
That's correct. But there was testimony that he didn't say anything to her while she was looking at the photos. He didn't in any way, point to any particular photo. That he didn't give any, hints, so to speak, to her as to who the suspect was. And so where the type of facial hair wasn't even described by the victim, who was the person who actually looked at the photo array, I don't think that there's any kind of a reasonable inference that a long beard would have been a significant factor in her making the identification of him. And this would be in contrast to the Commonwealth versus Thornley case, where there was a photo array and only one person was wearing glasses, and the two witnesses both testified that the glasses were a significant factor in their making the identification of him. Here, I don't believe, and I double checked the transcript preparing for the argument, but I don't believe anybody ever asked the victim why it was that she picked out the defendant from the array. Of course, it's the defendant's burden here to show by a preponderance of the evidence that it was impermissibly suggestive. But I don't believe anybody asked her why, and I don't think that we can infer that it was because of the long beard, where her description was merely facial hair, which, as the Chief Justice has already pointed out, could also mean sideburns, a mustache, or any number of things. And so where the pictures all appear to be reasonably similar characteristics, I don't think that the defendant has met his burden to show that the array was impermissibly suggestive. And if there's no further questions, then I would rest on my brief.
None. Thank you both. We will be in recess and we will resume at 11 o'clock.
Thank you, Your Honors.
Thank you. Okay, so I sent you guys, and you accept E 1822, Jeanette A. McCarthy versus Arthur J. McCarthy, Jr.
Good morning, Your Honor. Sandra Lundy for Jeanette McCarthy, the appellant. We respectfully ask you today to vacate the hybrid alimony award and the asymmetric property division in this divorce case as falling outside the range of reasonable alternatives available to the judge under her broad discretion. The two awards ensure, virtually guarantee, that the husband will be able to live, to maintain the elevated marital lifestyle that the parties both attained in 31 years of marriage, and that the wife will not. Let me first focus on the alimony issue. We know that alimony is a function of the ability to pay and the need of the recipient. Here, the ability to pay is given. The husband earned $418,000 in the year of separation. So the critical issue was the wife's need. And here the court made at least three critical errors. The first is that the judge used the wrong standard for benchmarking the wife's need. The judge found, this is at finding 41, that the parties lived a middle-class lifestyle for most of the marriage. And she used that middle-class benchmark at finding 85 to set the wife's need. The judge also found that the last years of the marriage, the parties attained an upper middle-class lifestyle. And our cases tell us that it's the lifestyle the parties enjoyed at the end of the marriage that's the true benchmark for need. So for instance, in the Young case, we read that on page 6, need should reflect the standard of living the spouse had at the time of the separation leading to the divorce. At the Goldman case, that the marriage began to, page 610, that the marriage began to deteriorate before the parties' lifestyle escalated is no reason to limit alimony to the parties' earlier station. Hassey, page 527, alimony is assessed at the time the order is issued. And all of these cases reflect the same premise that when you have a marriage, you have an economic partnership as well as an emotional partnership. The judge at findings 94 and 95 found that the parties had a true partnership, true marital partnership, and it's presumed that climbing the economic ladder during the marriage is a joint enterprise. So both parties should have been entitled to the elevated lifestyle to be maintained as long as there was money enough to pay alimony at the end of the marriage.
That elevated lifestyle was elevated for a rather brief period in a very long-term marriage, wasn't it?
It was elevated because of the long-term marriage. It was elevated because the parties worked together, because the wife, with her contributions, made possible the husband's working, staying away from home 70 hours a week.
Well, that was true for his earning capacity during each of the prior years as well. He happened to have a couple of very good years at the very end.
No, at the very end, he had he did have a couple of very good years. Again, you know, we can't anonymize that. We have to look at that as the cumulative effect of the husband's successes all along. And also,
suppose he was awarded a substantial bonus for the first time ever on the day before the commencement of the divorce action.
Well, that's not this case. You know,
I understand that, but I'm just trying to understand as you might anticipate. I'll walk it back in narrow increments. By let's say it's a month before, let's say it's 6 months before, let's say it's a year before. I mean, at what point does that become the station that the wife that should be the benchmark?
Well, one of the reasons that the husband earned a lot of money is the presence of the EBITDA bonus that during the marriage. And again, that was a bonus that was given to him during the marriage, and that was a bonus that his work. You can't separate his ability to work and his ability to succeed from the wife's ability to tend to the house and tend to the children.
I'm aware of that, but I guess I'm not talking about categories, I'm talking about numbers. As you know, his ability to work benefited from her assistance at home will in fact allow his career to continue to advance after the marriage. But as you well know, she is not entitled to participate in any improvement that occurs after the marriage is terminated, right?
Yes, but if you look at the way the parties lived their marriage, and you'll see in our brief, we take issue at the judge's characterization of the standard of the marriage as middle class in any event, because the parties paid full freight for the children to go to college. They went golfing continually. They spent at least 4 weeks a year on vacation. A lot of them in Europe or the Caribbean. They paid off their mortgage, et cetera, et cetera. So I think it's fair to say this is a fairly elevated lifestyle in any event. And by using, you know, terms matter here. And by the judge calling this this marriage with all of these perks a middle-class life, I think many middle-class people would love to have that life. It was an elevated lifestyle, and the judge made it very clear that she was not using an elevated lifestyle as the benchmark for the wife's need. Now, if
setting apart the descriptive characterization, again, just returning to numbers, because there was a substantial bump in the husband's income in the last 2 years of the marriage. When we're looking at alimony, do we? Your position, I take it, is that we take a snapshot as of the time of the divorce, and I'm just asking, is it literally the moment of the divorce in a 34-year marriage? Is it do the last 10 years matter, or is it just the last one?
Well, you know, I would ask, I think in Young, I believe it was a 24-year marriage. I'm not sure. In the Goldman case, the husband tried to argue that, you know, this marriage was broken way before I started earning a lot of money. And the court said that doesn't matter. So this is what the case.
But how long was the period in which the husband was making a lot of money? I mean, it was a fairly I don't remember the details, but as I recall the facts, it was a significant period that defined their lifestyle.
Your Honor, I don't have the exact years, but if I could move on to some other points
Sure.
Here about the alimony, you know, the judge basically concluded that the wife at the age of 58 at the time of the judgment, and with all her medical problems, was capable of obtaining full-time employment with benefits in this gig economy. And there is absolutely no support in the evidence for that. There is support for the fact that the judge didn't agree that the wife had didn't believe the wife that she had chronic neck pain. She thought the wife golfed too much. But those findings themselves don't necessarily lead to the conclusion that the wife is capable at the age of 58 of finding a full-time job with benefits. And if you look at
Well,
exhibit 20,
let me just stop you there for a moment. I don't, as I read the judge's rationale, I didn't see the judge imputing a particular element of potential income to the wife.
that is also a problem, Your Honor, because this case, you know, there's a two-step review that you have to do. One, did the judge consider all of the statutory elements? And two, was the judge's conclusions order, did it was her rationale adequately expressed in the judgment? That's the Redding versus Redding case, Bowering versus Reed. And you can't say that the judge here passed that second level review. She never made an affirmative finding of the wife's reasonable need. She never made an affirmative finding of the salary range that she was attributing to the wife. She never made an affirmative finding of the wife's probability of obtaining work in the relevant job market. She never told us how much of the wife's financial statement she was discounting.
How would you to find the specific needs when the wife is giving a false financial statement and isn't giving the judge the information he needs to find out what her needs is? Doesn't he have to spitball it?
No, not at all. Well, let me talk about two cases in relation to that. The first is the CDL case, and there the judge also didn't find a specific amount of attributable income. But what this court found is that the judge's other findings were specific enough that they could understand what the wife's attributable income would be. In the Young case, the judge also discounted large portions of the wife's financial statement. But Young teaches us this, that if for whatever reason you can't figure out what the need is as a raw figure, then the statute gives you two options. One, you can use the statutory 30 to 35% differential in the party's gross income in 53B, or two, you can deviate.
The statute says it can't exceed 30 to 35%. What's your basis that it can't be under 30%?
Well, I think that the 30 to 35% is, well, the reasoning of Young, basically Young says that when you determine need, what the judge is doing is he's or she is making a balance of sacrifices. When you can't determine need, the legislature fills in that blank for you. That presumptive, the presumptive measure.
That's not what the statute says. I understand that there is a school of thought among practitioners that that's what it means, but it's certainly not what the statute says.
But it's pretty much what Young says. That the 30 to 35% is kind of the legislator's assessment of where the fair balance of need should fall.
I read Young again just this morning. I didn't see that part of that was a presumption that should be applied in the absence of other demonstration need. As I read Young, it was a very, very clear statement that you look at the overarching objective is to identify need and to balance out the need, and Young explicitly recognizes a scenario that's not present in this case, which is where the resources are inadequate to meet the needs of both parties. But you know, where you have enough to meet the need, that's the need, the wife's need or the non-payer's need is the benchmark. Right.
If the judge had made a finding of need or even the range of need.
That's a different argument. But the 30 to 35% is not a default setting if the judge doesn't want to engage in the inquiry into need or is otherwise feeling challenged by to identify that.
Well, the judge has broad discretion in setting the amount of alimony. There's no question about that. But the legislature, I think, has provided some careful guidance on that. You know, I would like to also say that we have to look at alimony in the way that it meshes with the property division here. The judge gave the husband 80% of the SARS account.
I'm sorry, but before you move off of alimony, I have one last question, which is, to what extent are you challenging the alimony is too low, and to what extent are you challenging that it shouldn't be contingent? Which I mean is, if we don't think it's too low, do you still want us to decide whether it should be contingent or not?
It should not be contingent. It should have been the differential between the parties' gross incomes at the time of the divorce.
What I'm asking is, if we don't agree with that, if we think the amount is about right, I'm not saying we do, do you still want to challenge the contingent nature of it?
Yes, and I'll tell you why. These parties have already been to court quarreling over the contingent nature of this award, and that's one of the reasons that our law favors making this kind of award definite, because it prevents these kinds of quarrels between the parties. I do want to say that we need to look at the asymmetric award of the SARS and the ESOP benefits, because what the judge's asymmetric award does is ensure that the minute the ink is dry on that judgment of divorce nisi, there is a huge wealth gap between the parties. Now, this was these benefits were accrued during the marriage. They were awarded during the marriage. They were status-based and not merit-based. And they should have been, and the wife should have been entitled to 50%. For the rest, I'll rest.
You have your brief there. So, thank you very much.
Thank you.
Okay, Attorney Giordano.
Chief Justice, members of the panel, if it please the court, my name is Catherine Giordano, and working together with Richard Woods, we represent the appellee, Arthur McCarthy, the husband. It's pretty clear that the Young case is pretty much the center stage in this case, and its current mandatory case law on the subject of alimony after the Alimony Reform Act. Under the Young case, the late Supreme Court Justice, Chief Justice Gantz, held that it was error to award alimony, which amounted to more than the wife's needs due to an upward trajectory of the husband's income after divorce.
But the linchpin of alimony and a property division, there's broad discretion. There are statutory factors, but the judge needs to express the rationale in terms that are adequate to allow us to understand what the judge did.
Yes,
I will confess. I mean, I'm not as bright as Chief Justice Gantz was. But I read through the rationale on both the alimony and the property division, and on the two retirement accounts, and on the methodology for the alimony. I'm not sure I can figure out what methodology, what formula, what approach the judge was applying.
Well, I would suggest that the judge made reference to, in several paragraphs of her findings of fact, which supported the action she took on alimony. I believe those are detailed in our brief.
Well, when you say the findings, there was a finding that she was underemployed, but she doesn't quantify that, and the rationale on alimony appears to me to maybe a little obliquely, but to disclaim any reliance on a particular amount of additional income that the judge thought the wife could earn.
I think it's readily apparent when you look at the findings of fact and the judgment nisi that Judge Gargas paid careful attention to case precedent, particularly in the Young case. And it was proper under Young for the trial judge to use need-based alimony formula, a need-based alimony formula.
What did she say was the wife's need? I mean, I wasn't able to follow, and when I was in high school and taking geometry, we always had to show our work. That's sort of it seems to me, the watchword for explaining the rationale for this kind of an award. She may well have taken all of the factors that she should have taken into consideration. There may well be a perfectly sound rationale for the asymmetrical division of the retirement accounts and for the determination of alimony. But again, I'm not the brightest bulb in the barn, but I'm not able to follow the tea leaves and figure out what the rationale is.
I believe that that there were several hints put into her findings of fact. This is a case that hinges.
It's like more than hints.
Right, but she, in a very large paragraph in the findings of fact, I recall that she said that she did not find credible the wife's financial statement as to her needs. It also differed with her testimony at trial when the wife was first asked about why she wants alimony. And what the judge did was the very difficult job of how do you proceed when the wife has not met her burden of proof under the Salton case cited in our brief, which is to disclose your needs, your financial needs in alimony to the opposing party and then to the court. And she failed.
That was less in terms of the credibility or integrity of the statements than I think the judge was irritated by the attempt, as the judge saw it, to include single long-term quasi-capital expenses in ordinary income or ordinary operating expenses. But it's easy enough to back those out. It's easy enough even to discount specific line items that the judge may have thought were inflated. But at the end of all of that, it is incumbent on the judge, it seems to me, to state the amount that the judge believes is the need and to explain how the judge arrived at that figure. And here, I'm not sure we have that. Attorney Giordano.
I'm sorry, I can you hear me, Your Honor?
Yes. Yes, continue.
Okay, I think you are correct that the judge does tell us the portions of the financial statement which she did not find credible and the reasons for which she found that. But she was left with the difficult task, the same as the judge in the Young case was faced with, when the wife in that case similarly did not specify her needs in the context of alimony, the way litigants have done for many, many decades. But I think it's important to note that she used the need-based formula for an important reason, and that was that she made a finding of fact that the husband was able to afford alimony. And that took her completely out of the balance of sacrifices mode that came from the Pierce case originally. Because the husband was able to pay, the only question before the court became what Judge Gargis called the reasonable needs of the wife, given the lifestyle. Now, if we go back to that Young case, it gives us so much information, but I don't want you to take my word for that. I'd like to call your attention to a Rule 128 case this court published on August 20th, 2020, after our brief was written. That is the case of CMA versus JTA 98 Mass App Court 1109, which interprets Young in much the same fashion that the husband does in his appellate brief. It is helpful and persuasive because it similarly involved a wife whose earnings were far less than those of her husband, and a wife who argued that the judge should not have used need as opposed to a range-based alimony award. And I think it will help clarify a lot of the issues in this case.
Counselor, another thing that Young teaches us is that we shouldn't have a contingent alimony award unless the payer has such fluctuations in his annual income that he wouldn't be able to pay the reasonable fixed award. I didn't see that, but maybe I'm missing it, the evidence that would justify the contingent nature.
I think that the Young case did say that you shouldn't have a contingent award. However, it said that I think Judge Gantz was very, he sort of covered all the bases, and he says that he doesn't mean to say that there would never be a good reason for having a contingent award, such as when you have variety and fluctuation in income. And I believe that Judge Gargis saw this as a case of fluctuating and uncertain future income.
Well, I mean, I think Chief Gantz was talking about an extraordinary case. There's going to be fluctuation in income, particularly where income is based on to a substantial extent on discretionary bonuses, and that, as you're well aware, happens in many cases. So I don't think the mere variability of annual income is the ticket to avoid the general disfavor of contingent income, and for reasons that apparently are not motivating the appeal here, because in Young, the concern was that the alimony payment would ratchet up in future years in a manner to which the wife was not entitled. We've got a little bit of time left. I'd like to hear from you on the division of the retirement accounts, because again, there may be an explanation. But if there was, I didn't see it in the judge's either in the rationale or the judgment or the decree.
Okay, to begin with, both the ESOP vested and non-vested interests and the SARS accounts vested and non-vested interests were included in the marital estate, and my sister counsel does not take issue with that. I think if you look in head note 23 of the Young case, I'm sorry, not the Young case, the Bacanti case, Bacanti v. Morton, it specifies once the judge decides to place these benefits into the marital estate, she has broad discretion in how she divides up.
I'm not quarreling with the scope, existence, or range of her discretion. I am asking, in exercising that discretion, she has to offer an explanation about why she's exercising her discretion in a particular manner. And again,
yes, I believe I believe that she is, if you look at the dates of the awards of the shares in the ESOP account, beginning on 12/31/14, and then 12/31/15, and then 12/31/16, you see that her percentage award makes perfect sense, because the wife's contribution to the ascertainment of those assets decreases over time, because first of all, there was testimony at trial and evidence that I cite you to specifically RA3, page 39, that the ESOP was created to attract, retain, and reward for future performance. And the case law tells us
the basis that would have supported the award is a different matter, it seems to me, from the articulation of that basis by the judge in expressing that result. You may very well be correct that that's what the judge was thinking.
I
just not very good at figuring out what other people are thinking when they don't say it.
I believe that you can sort of figure this out and piece it together by my going to the SARS accounts for a moment, Your Honor. First of all, you know from the case law that when future performance is involved, as it is with both the ESOPs and the SARS accounts, that's something the case law sort of makes a dividing line. The motivation for the SARS accounts was to motivate their employees to perform at a high level with ownership mentality, to motivate them. And that's a future, that's something that the divorced spouse has to do in the future. And so the judge has to determine how much contributed to that plan's benefits during the marriage and how much afterwards. And you'll notice that there is also a formula in there in terms of how long the working employee had with the benefit. And you'll notice that she gives less of a percentage on SARS. And why is that? Well, the SARS account started January 2016. And the parties, the wife filed for divorce in April of 2016. That was only 4 months that she could possibly have contributed to supporting him to getting that benefit. So I think that the judges under the police law,
where does the judge point to that as a reason?
The judge doesn't point to that as a reason. However, she's using case law as her guiding format as to how she comes up with the distribution, which is completely within her discretion.
You have a case, you know, and I'm not saying this to be difficult, but do you have a case where the judge does not offer a rationale, but the record indicates a basis on which the judge could have relied.
Not one that comes to mind. No, Your Honor. I do believe she followed Bacanti to the T.
Well, you believe that the result is defensible based on the record. And
Yes.
I'm asking a different question, because my understanding of the law is that the judge is compelled to provide to basically connect the dots for us in order for us to conduct a review that we must conduct.
Yeah, again, I do stand on that head note 23 in Bacanti, which says once the judge decides that these specialty accounts are part of the marital estate, it is completely within her discretion, looking at the whole grant of this marital estate, to make the decision as to how to apportion them. And she's quite clear in her findings of fact that she believed an unequal distribution was appropriate. And she's looking at the whole package here.
Anything else?
I just wanted to quickly mention on the lifestyle issue, I'd like to ask this court to please take a look at the Social Security statements for both parties, which were included in the record appendix, because they tell an accurate story about the marital lifestyle. Based on the information before the judge, the wife testified she shoveled snow from a 4-car driveway and a rooftop. That was the Winchester home. She did windows and took care of everything in the house. She worked for a time as a waitress. And the Young case speaks of the fact that we look at lifestyle during the marriage historically. And it isn't just the last 2 years, but the judge did that. She made a decision as to how you look at lifestyle historically.
Thank you.
Thank you, Your Honor.
That concludes this case. Thank you both. We will return to the waiting room and continue with the next case on our hearing list.
All right, we are live and recording.
Continuing with our list, we have case number 2019 P1380. This case is impounded. It's John Doe number 415324 versus the Sex Offender Registry Board. You may begin.
May it please the court, Attorney Ilse Neering representing Doe. With regard to the first issue presented, the abuse of discretion to deny the funds for the Portuguese-Brazilian interpreter, what is important here is the record reveals that the particular attorney who was assigned to represent Doe in his classification hearing was unable to communicate with his attorney, with his client. And he even stated in the record at volume 3, page 178 and 172, that the problems in communication prevented him from providing effective assistance to his counsel. And he also stated in the record at volume 3 on page 176 that a Brazilian Portuguese interpreter from CPCS, the Committee for Public Counsel Services, was not available to him. And so he's seeking funds in order to communicate with his client. And it's not relevant, as the SORB points out in the brief, that there are certain people at the Massachusetts Treatment Center or a police officer who arrested Doe all appeared to be able to communicate with Doe and could understand him. The only thing that mattered here was this particular attorney who was assigned to represent this particular client could not communicate with his client and needed an interpreter to go with him to the jail. And this hearing examiner makes a clear error of judgment when she denies those funds, because this Doe is denied the effective assistance. This Doe is denied effective assistance of counsel.
Are you claiming error on the part of the hearing examiner, or are you claiming ineffective assistance of counsel because apparently counsel could have engaged an interpreter without seeking leave from the hearing examiner?
Well, he writes in the record at 3 on 176 that he was unable to acquire a CPCS interpreter, and he's seeking funds to get an interpreter.
I thought CPCS was the source of funds within those parameters. I mean, I think the issue was that no interpreter was available, right?
He wanted funds to acquire a non-vendor CPCS. He wanted to acquire a non-vendor interpreter.
Why?
because he couldn't get one from the Committee for Public Counsel Services.
Where is that clearly laid out?
He wrote it in the record at volume 3, page 176. He writes it in his proposed findings of fact and conclusion of law.
Is there an affidavit? Sorry.
Isn't that a little late to tell the judge that the examiner that you need this special thing after the hearing's already happened? Didn't you need to tell the examiner that before when he's asking for the money?
Well, he did ask for the money before, and it was denied.
He asked for money that he's entitled to as of right, and that examiner says you do it yourself. If that's not working, doesn't the lawyer have to tell the examiner that?
Well, I think he tried to tell her, and that was stated in the motion for the continuance as well. It was made clear.
Did you raise this argument in the Superior Court?
No, that's why, I made the standard of review substantial miscarriage of justice.
So in Doe, I noticed you didn't cite any SORP cases for this theory. In Doe 203-108, we held that if something isn't raised in the Superior Court, it's completely waived, and it can't be raised on appeal. Am I misinterpreting that case, or why is that case? Why should we not follow that case?
I'm afraid I'm not familiar with it. My understanding is that it's put forth in the RB petitioner case that we can raise substantial miscarriage of justice issues in the appeals court in these SORB cases, and that's the RB petitioner case, which I cite in the standard of review, and that's also in training materials promoted by the Committee for Public Counsel Service. So
RB petitioner was a SORB case?
It
doesn't sound like it.
I don't know right off the top of my head.
It sounds like an SDP.
Yes, I think was what it was.
I think the difference that Justice Ditkoff is alluding to is that we treat SORB cases differently in terms of waiver. The classification is different than a confinement.
Well, if that's what the appeals court has determined.
I'm actually, I don't remember whether that was an appeals court case or an SJC case, but the distinction is in terms of the extent of liberty interest that's implicated by a civil commitment as compared to the level of classification.
All I know is that it's been discussed in trainings and whatever, that this petitioner case is something that
you might want to examine that distinction between the two types of cases.
I have understood today. Thank you.
All right. You have some other matters that you want to talk to us about?
Well, I did want to discuss my second issue about the fact that Doe was an illiterate, and the record isn't persuasive that there was a knowing and intelligent and voluntary waiver of the patient psychotherapist privilege. Is this panel telling me that that is off the table now?
That was also not raised below, I gather.
No, it's a substantial miscarriage of justice.
Do you have any precedent, I don't know the answer either way, that the waiver of a statutory privilege has to be knowing, intelligent, and voluntary? You cite a constitutional custodial interrogation case, but do you have any precedent for that proposition?
The case I cited, I believe, was Hilton.
Right, which is not a statutory privilege. Do you have any authority for the proposition that waiver of this statutory privilege requires a knowing and voluntary waiver?
As compared to waiver of a constitutional right.
I understand.
You understand the distinction, but you don't know the answer.
Exactly.
All right. Well, we won't insist that you continue to confront it if you don't know.
So, I guess my question you know, I think that the thing to think about here is that in DYS versus juvenile, that there was no lamb warning and there was no waiver, and that was a substantial miscarriage of justice. This case is so analogous that in the totality, there isn't persuasive evidence that there is a knowing and intelligent involuntary waiver. This man wasn't illiterate. He couldn't read the form, and the form has a place for verification for an illiterate, for somebody to verify that this illiterate was read to. And this, there has to be some fundamental fairness if we have these statutory privileges, that if it's not a waiver that can be knowing and intelligent and voluntary, then I don't see why it has to be a case directly on point for this waiver. I mean, this person suffered substantial prejudice. It was a substantial miscarriage of justice, just as it was in the DYS versus juvenile case. There, he wasn't given the warning, and there was no objection. And in this case, that there wasn't a knowing and intelligent involuntary waiver. We know that he couldn't read, that other prisoners read to him, and they wrote his homework assignments out for him.
Can I interrupt you? And I'm sorry to do that. I appreciate the significance of the point that you're making, but I do have a question about a different issue that you've raised with respect to the sufficiency of the evidence supporting the level 3 classification. Could we hear from you on that?
Is there a question?
Yes. Can you indicate to me what's the heart of your argument about why the evidence was insufficient here?
Well, I think, first of all, what happens here is that this particular examiner doesn't even address what is the public safety interest served by active dissemination of Doe's identifying information. And active dissemination means that people go to the neighbors, the police will go to the neighbors, they will inform the neighbors that there's a sex offender living here, they go to schools, they go to organizations, they put posters in post offices and libraries. Doe is an incest offender. And the hearing examiner established that the parent of every single child in his family knew that he'd been convicted of a sex offense, and they were aware. So his family is on notice. And this particular Doe is 62 years old. And we know from the MTC records that he suffers from work-related injuries. So he's not in the greatest of physical condition necessarily. And there's no evidence that he's about to commence an intimate relationship and start a new family with a woman who's 20 to 40 years younger than him with prepubescent children. So the public safety interest that's served by active dissemination for this particular Doe, given his age and given his preferred victim pool is on notice, is not established by clear and convincing evidence. And in terms of the high risk to reoffend, you know, I think that if, you know, we look at the SORB's argument about the applicability of non-compliance with community supervision, you know, there's no finding on the Superior Court docket that this arrest in January of 2012 violated the terms. There was no finding that he had, you know, violated the terms of his release. And this sex for a fee case in the end was...
The conduct was criminal, solicitation, right?
I beg your pardon?
I said the conduct was criminal, solicitation of a prostitute, right?
It is criminal, yes.
I mean, I don't know what was in the record, but I'm not aware of many release conditions that don't include refraining from criminal conduct.
Yes, but there's no finding on the Superior Court docket that he, you know, violated the conditions of his bail release. And the crime
By committing a criminal act?
The case was ultimately dismissed.
I understand, but he was picked up for, I mean, he admitted to the arresting officer facts that were certainly sufficient to support a charge.
That's probable cause standard.
It would have been beyond a reasonable doubt if the case had gone to trial. Why the case didn't proceed is a different question.
I don't know. But you know, when we use this alleged sex for fee to increase his classification under Factor 37, the nature related to sexual behavior, it gets to be a bit difficult then, because this is consensual sex. It's not a sex offense. It's between consenting adults.
It was at a time when he was aware that he needed to restrain his impulses. And that's why, in the hearing examiner's own words, why it was troubling. And the hearing examiner was also troubled by the unwillingness of the family members to acknowledge his offense.
And that implicates then Factor 33,
right.
Which is a risk and mitigating factor.
So I mean, I understand there are a variety of different factors, and the hearing examiners put it all into the blender and try to figure out what to do. And you know, there were risk mitigation factors, including his age. There were risk exacerbating factors, including his offense while he was on conditioned release, supposedly on his best behavior, and the unwillingness of his close family members to acknowledge his conduct and his own denial of his misconduct.
I see I have 30 seconds left, so I rest my case.
Thank you.
Unless there are any further questions. Sorry.
Thank you. Okay, Mr. Chanel.
If it pleases the court, Your Honor, David Chennai for the board. I would point out again, and I think you touched on that, the fact that the majority, I think only really one issue was a live issue. The other issues were waived.
Well, you know, let's talk about waiver. In your brief, you cite several times Carey versus the New England Organ Bank
yes.
on the topic of waiver, but that's a decidedly civil case. And as I'm fond of saying, waiver is alive and well on the civil side of the house. These cases are of course, civil.
Correct.
But both these cases and the SDP cases operate to some extent under a different set of rules.
Correct.
Why did you cite an exclusively civil case if you've got a classification case that would support the same proposition?
I think the problem is it's more cutting and pasting. We've been using the Carey case prior to the Sword case, and I think I just kind of carried it through more than anything.
Why don't you do yourself and us a favor by updating your forms and picking up the case that Justice Ditkoff, it will, if nothing else, alert your adversaries that there may be an issue that they need to address.
I will take care of that, Your Honor. But again, we do have a waiver issue in place on all but really the substantial evidence portions of the case.
Let me ask you something about that.
Sure.
Normally, a claim that the internet dissemination wasn't decided by the examiner is something that we don't worry about, whether it was raised in the Superior Court or not. This is one a little unusual in that the Superior Court motion for judgment on the pleadings was filed after Doe 496501 comes down. So I'd like your view on whether the question of whether we need to remand for consideration on the internet dissemination is something that's waived or properly before us.
Well, I think the Supreme Court in both 496501 and 22365 specifically said that these cases, that pending cases that where the findings weren't made below are live issues at the appellate level if they were pending at the time of the cases coming down. I think 23656 gives us the outline of what a court has to look to on a pending case to determine whether or not remand is necessary or unnecessary. Again, the court in 496501 says if the facts are sufficient, the appeals court can decide that, as well as the superior court if the case was pending in the superior court at the time of 496501. In this case, the evidence is overwhelming, and 23656 said first you look to whether or not the hearing examiner's decision was properly made. And in this case, the board's position is the hearing examiner properly made the decision based on both substantial evidence and a proper application of factors to that evidence. Then the second thing you look to is the danger, and vis-a-vis the factors that were used, such that his current danger would serve a public safety interest should he need to be published. And in this case, you do have some high risk factors that show danger, such as a prepubescent child shows an extra danger.
As your sister counsel has observed, there are different types of prepubescent children and offenses against them, and this was not a stranger offense. It was a single victim, you know, and he's, I mean, I hesitate to use the term because I'm older myself, but he's elderly.
Well, he's actually at that time was the same age as me, so I'd hate to think that he's elderly. But at the time of the decision,
I think we both are able to shop during the early hours of the
This is true. This is true. But the difference here is that there's some factors involved that differentiate this situation. First of all, one of the problems, and in the notes you saw, they felt his wife was a negative influence in this because she refuses to believe that he committed the sex offenses. Also, his family refuses to believe he commits the sex offenses. And they've all said, at least the nieces said, that they would allow him unsupervised visits with his children. And he's moving into a home with...
But just on that point in particular, how does that, they are already aware, right? So what is the purpose of internet dissemination? It's not to make them aware of the offense. If they are foolishly going to give him access, that's a different question. But I'm not sure I see the nexus on the purpose. I mean, look, it may be that if the examiner under the new cases makes a specific finding and a conclusion that dissemination is required, we would affirm that. But it's not crystal clear to me on the face of the record that the need is overwhelming to avoid the need for a remand.
Well, you're presuming that upon his release from incarceration, that he's actually going to live with the son, not live on his own, not have access to other children in the community. I think your argument presumes
other than a family member.
Excuse me?
He's never offended against anyone other than a family member.
True. It was a stepdaughter, actually. It wasn't his actual biological daughter. And I think that's also a distinction in this matter. Because again, there's no guarantee that he is going to solely reside where he said he was going to reside while he was still incarcerated. And that's
all of those are factors that may well lead a hearing examiner to conclude that the dissemination is needed for the public interest. But if I'm reading the guidelines from the Supreme Judicial Court, it's not, I have to say, superficially abundantly clear to me that that this is one of those cases where where that conclusion is compelled by the record without asking for the hearing examiner's input.
Again, that's your prerogative, and you have the discretionary authority under 23656 and 49650 to make that determination. I'm putting forth the board's position on this matter. And again, if this court disagrees with that, then you would remand it back for a finding on that issue. And I think that if you did that, the board would at least would request that the remainder of the case be upheld and that the remand be solely for the purpose of making that determination.
And as you've cited, the remaining issues are unpreserved.
Correct. So if there's no other questions, I could rest on my brief at this point.
Seeing none, thank you both.
Thank you, Your Honors.
This concludes the argument in this case, and we will move on to our final.
All right, we are live and recording.
All right, we've reached the sixth and final case on our hearing list today, case number 2019 P1670, Rick Yatsenik and another versus the Old Wharf Village LLC and others. You may begin.
Thank you, Your Honor. Attorney Eric Price on behalf of the Yatsenik's, Rick Yatsenik and Joel Yatsenik. Your Honor, this is an appeal involving, Your Honors, this is an appeal involving a developer who bought a defunct motel, condominiumized it pursuant to 183A, and then proceeded to start marketing and selling the units as single-family residential condos without seeking any zoning relief. Now, Your Honors, the central issue on appeal here is whether the language in the Yatsenik's unit deed, which says that the unit is for single-family year-round residential use, whether that language constitutes a covenant pursuant to 183A, Section 9D. 183A, Section 9D states that the grantor must list the use and any restrictions on that use for.
Did you move for directed verdict during the trial, or your predecessor?
Well, no, Your Honor, we didn't move for directed verdict simply for the reason that, as the second issue which is the judge changed the breach of contract claim. The judge in the jury instructions completely invented a new claim. He changed the claim from the breach of contract claim, which was always our case, always from the inception of the complaint, to on a purchase and sales agreement, well, which in an exculpatory clause, and then sorry.
I'd like you to tell me where the judge told the jury that they couldn't use the deed as a basis for the breach of contract claim.
Well, it's right in the jury instructions, Your Honor. Let me just pull up the record appendix site. In the altered jury instructions on record appendix 1, page 795, and going forth from there.
I would like you to tell me something in the instructions as that were given to the jury.
Right, the judge at the lower court level, Your Honor, said the plaintiffs contend that they relied only on the MLS listing sheet in reference to their breach of contract claim.
That's not what the judge said. The judge said the plaintiffs maintained they relied on the multiple listing sheet. He didn't say only.
Well, he again, well, there was other evidence that he's pointing them only to the MLS sheet, where, Your Honor, we had other evidence there that we would have argued if we were going to go behind the deed. And that's always, Your Honor, the exculpatory clause is a defense to an action sounding in tort. It's a defense to an action sounding an intentional misrepresentation. It's not a defense to a breach of contract.
Since there was a tort, the judge had to instruct on that. Where did the judge say that you couldn't rely on the deed as the basis of the contract?
Well, he based the entire jury instructions on the purchase and sale agreement. He said, now in regard to the purchase and sale agreement, I don't have it, but he said the purchase and sale exhibit listed as Exhibit 7. Sorry, Your Honor.
Purchase and sale agreement is the only one that has an exculpatory clause. So when he's discussing the exculpatory clause, he has to discuss that. But where did he tell the jury that they couldn't rely on the deed for the breach of contract? He actually instructs them about what the contractual elements of a deed are, about the covenants that are quitclaim covenants and what they mean. So,
right, but then he says that the Yatsenik's contend that they rely on a multiple listing sheet, and the jury instructions imply that that is an automatic defense. And again, that's not what we pled. Our claim is always.
Why did you tell the judge that the way he was doing it was implying that the deed couldn't be used as the basis of the contract?
Well, if you move further down the line of the altered jury instructions, the judge clearly states to the jury, now not in as in the breach of contract claim, the exculpatory clause is not an automatic defense to intentional misrepresentation. So when he says that, he's saying it's not for intentional misrepresentation, but therefore it must be for the breach of contract claim. He's saying he implicitly is calling it an automatic defense. And Your Honors, again, I have to emphasize that exculpatory clause is a defense to an action sounding in tort. It goes to intentional misrepresentation. And that exculpatory clause by the doctrine of merger, sorry, Your Honor.
Where did you preserve this? Where did you tell the judge of this problem? You told the judge you wanted to tell the jury that the basis was the deed. He wasn't willing to do that.
Right. Well, Your Honor, oh, sorry.
What he said was negating the deed as a part of as the basis of the breach of contract.
Your Honor, we did so in a number of ways. First, immediately upon receiving the email on the Sunday before jury deliberations were to take place, we filed a written motion to reform, and that's in Exhibit 1 on page 807. I'm sorry, Record Appendix 1, 807. And then, Your Honors, at the sidebar,
so
it was
that what you asked was for the judge to say what the quit claim covenants are, which he did.
no, that motion to reform, Your Honors, respectfully, was to state that the action again was always from the face of the deed, and our claim never went before the jury. Our claim was on the deed, and this Commonwealth has found that serious issues arise when a lower court bases a decision upon an issue that is not presented or before the parties, before the court. And that's Messina v. Sheff, Your Honors. And that's exactly what the lower court did, respectfully.
Lower court, only thing the lower court didn't do of your requested instruction.
The lower court,
where he says what your claim is.
We asked the lower court to strike any reference to the exculpatory clause to a purchase and sales agreement with an exculpatory clause contained therein. And also any reference to a multiple, sorry, Your Honor.
Where is that?
That's in the rationale, the reasoning behind it on page Record Appendix 807, Record Appendix 1, 807, our motion to reform. The reasoning for that is that our claim was based on the deed. And an exculpatory clause, and this is by the doctrine of merger by Pybus, this court in Pybus v. Grasso has ruled over and over that the doctrine of merger stands for the fact that prior negotiations are all discharged, and the only undertakings left are those that are embodied on the face of the deed. Here, Your Honor, we have a covenant.
The exculpatory clause doesn't appear anywhere in this pleading. So
the exculpatory clause, Your Honor, is contained in the sorry, Your Honor, is contained in the purchase and sales agreement.
No, but
so we asked
I'm asking you where you told the judge that he had to get rid of this thing about the exculpatory clause or move it somewhere else or change it. Where did you tell him that?
We told him that right on the motion, and then at a sidebar, Your Honor, the next day, we instructed the court that again our claim was on the deed, that our claim was never on exculpatory clause.
Where in the motion did you complain about the exculpatory clause?
Well, Your Honor, again, the exculpatory clause is contained within the purchase and sales agreement. We asked the court to strike the whole purchase.
You just told me that you complained about the exculpatory clause to the judge in this motion. Correct. And a sidebar. And I would like to know where in this motion you did that. And then I'm going to ask you a transcript site for the sidebar of that.
Well, again, Your Honor, it's and there was a whole discussion of the previous day that everybody was in complete agreement that an exculpatory clause is a defense to an action sounding in tort, is an action sounding. And I can give the record appendix for that, Your Honor, where trial counsel for the plaintiff states, and this is at record appendix volume 4, 1255, and I think we're going away from the contract claim, that we have to go over to the intentional misrepresentation on the 93A. The jury would still look at those prior statements. Nothing in the P&S would foreclose prior statements to see if they were defrauded. And that's totally different from the breach of contract claim. And then defense counsel, again, this is at 1255, who was standing at sidebar, states, I think the exclusion is relevant to the other claims. That's what you're saying, right, Brian? And she's referring to trial counsel. And then before that, on 1254.
Reading counselor, the next thing the judge says is, okay, let me take a look at it.
Right, but prior to that.
Instructions, I'm asking, once he sent the instructions, where did you tell the judge there was a problem with the exculpatory clause?
Again, it's contained within the purchase and sales agreement. We asked the lower court to strike the whole purchase and sales agreement, which obviously the exculpatory clause is contained within the purchase and sales agreement. And again, we're only looking, it specifically references the MLS sheet, which is right in the exculpatory clause. That's the document that the court said that the plaintiffs were relying on. But again, if we had to go down that route, which we were foreclosed from because the court completely changed that on the eve of the closing arguments, we would have presented other written representations. We would have presented, Your Honor, respectfully, the advertisements. We would have presented the website where the defendants represent that this is a wonderful place to call home. We would have represented all of those documents. And it was, again, this issue was noted under objection. The trial court on page, I'm sorry, in the record appendix, Your Honor, he says, I'll note your objection.
Let me see if I have a question in a different area. Do I understand correctly that the special permit that was reflected in the condominium documents and referenced in the unit deed was subsequently amended?
Yeah, the special permits, Your Honor, were always in flux.
And as things stand today, year-round residence is permitted?
Absolutely not, Your Honor. It's the special permit, this 2015 special permit, which is in Record Appendix 1 at page, or Record Appendix 2, excuse me, page 177, specifically states that the property is subject to 1011, the Town of Dennis zoning bylaw section 1011, which is in Record Appendix 3, page 250. And the section 1011 prohibits, restricts the property to only motel transient use subject to Massachusetts chapter 140, section 12A, and then timeshare use subject to 183B. There has never been any residential use permitted at Old Wharf Village condominiums, nor has there's never been any residential use. And that's, Your Honor's, a complete lie, frankly, in the appellee's brief that we find repugnant. So we would like to address that. But then, Your Honor's, moving on to the 93A, which is another essential issue, is the lower court made a ruling that when the defendant admitted that he doesn't tell people that these are actually motels, that you can't live there. The defendant admitted that on the stand, and the lower court made a ruling that we weren't allowed to prove the elements of materiality, capacity to deceive, and actual deception as it relates to the Assenix 93A claim. Yes, the defendant admitted that, but what he didn't admit was that he testified that, no, I don't think it's an important thing for people to know. He doesn't, so we had that burden, Your Honors. And
did your clients testify to that effect?
I'm sorry, what was that, Your Honor?
Did your clients testify to the list of considerations that you had hoped to call other witnesses to speak to and were not permitted to do?
Well, Your Honors, yes, our witnesses testified that well, they were misrepresented and such, and we wanted to put the unit owners up there to corroborate as well as refute or show, again, materiality, as well as a myriad of other issues, Your Honors, where we have common pattern or scheme, you have business practice to show it was his business practice within the meaning of 93A, and we did an offer of proof all to this, showing this to this extent, Your Honor, Your Honors, to show as to the value. Defendants were able to argue through documentary evidence with the deed over and over that the value of these units were selling like hotcakes. And that's just simply not true, Your Honor. Well, it was the fact that the unit owners would have testified to say that, no, I never would have paid this much money. I never would have, again, even stepped foot into the property had I known that these were actually motels. And the big issue here is that the defendants were able to say that everybody was happy down there. We weren't able to refute that. The unit owners would have said they were just as upset as the Assenix. They didn't want anybody sleeping in their bed. And Your Honor—
Could I interrupt you one question? Chief, could I ask one question? It may go over the couple of minutes. Counsel, can you tell me, is it your client's position that this is a changing tax, in fairness to you, that the language in the unit deed that relates back to the master deed. Does that language have any significance from your client's point of view? And if it does, what is it?
Well, Your Honor, the language, our position is the language in the unit deed is a covenant pursuant to 183A 9D. And that in relation to the master deed, Your Honor, the master deed at the time of the closing never really put anybody on notice for the simple reason that the town of Dennis in the 2015 special permit, and again, that's at Record Appendix Volume 2, page 177, found that the master deed was so confusing that it didn't give anybody any information as to what this actually was. And that's why the town of Dennis mandated that the defendants were supposed to amend the master deed to actually reflect that it be subject to Section 1011 of the town of Dennis zoning bylaws. And Your Honors, I recognize that my time has expired. If there's any other questions, I would rest on my brief.
Thank you.
Thank you.
For the appellee.
Good morning, Your Honors, and may it please the court. My name is Juna Perkins, and I represent the defendants' appellees in this matter. This court should affirm the jury's verdict in favor of the defendants because there was overwhelming evidence that the defendants' acts or omissions did not cause the plaintiff appellant any harm, and that the appellants failed to meet their duty to mitigate damages, and that these two things make any error on the part of the trial court superfluous. First, I want to quickly address the issue of personal liability. The plaintiffs have said that Charles Edgar should be individually liable. The jury specifically found that everything that Charles Edgar did was in his capacity as manager of Old Wharf Village, and as such, it should not be held personally liable, and nothing on appeal suggests otherwise. Every statement and act that is referenced in the appeal is related to the acts of in effect of Old Wharf Village, and therefore the court should not find Charles Edgar personally liable for anything.
Why is that? If Charles Edgar engages in unfair and deceptive practices, why can't he be found liable for that?
Because Old Wharf Village is an LLC, which provides, which means that it has to be, any act of Old Wharf Village has to be done by a person because that is who sort of the vehicle, and as such, somebody has to make these statements, but he's making the statements on behalf of Old Wharf Village.
An LLC only protects the owners of the company, not its employees. If an bagel is an LLC, which I assume it is not, but if there's a bagel place that's an LLC and one of the employees there, runs into me or knocks me down or hurts me, he doesn't get to defend that on the grounds that he was working for an LLC.
No, but I mean, these were acts all within the scope of his employment. These were all done. These were not, a car accident on the street in which he shouldn't have been involved in or shouldn't have been doing.
Even if it's in the scope of employment, an employee can be found liable for the actions they do, regardless of the corporate structure of the company.
I suppose. I mean, but the fact remains that there's nothing, that there really is nothing that he did that was outside of his capacity as manager.
Why does it have to be outside his capacity? As long as it's his actions, why can't he be sued for it?
That is the purpose of having a format like that, an ownership format like that.
The purpose of that was to protect the owners of the company from liability, which in a partnership, they'd be liable for everything.
Attorney Perkins, in your introductory comments, you cited the plaintiff's failure to exercise appropriate mitigation of their damages, and I'm curious, what do you have in mind when you're referring to an obligation to mitigate?
So, both under the breach of contract claim, they had a duty to mitigate their damages, and they didn't. They acknowledged.
You said that, but I want to know what is the nature of the mitigation that they were supposed to undertake?
They could have sold it, and they could have rented it. There was nothing in the special part. These units were meant to be transient use. They're all small. They all scream vacation. They're beachfront condominiums. I believe Unit 204 is less than 600 square feet. Doesn't have an oven. They are regularly rented as vacation rentals, and there was testimony that they rent for something like $1,800 a week during the summer months. The special permit clearly allowed that. That was the purpose of the whole development. They also could have sold if they argued.
But that goes to the potential damage award, not to the existence of liability.
Yes, that's true.
I had understood that the verdict, in part, finding no liability, was based on the jury's conclusion that any reliance was not reasonable because a reasonable person would have understood, based on a review of the zoning and title records, that this property was for transit use only.
Yes, I mean, certainly on the intentional misrepresentation claim, it would appear that the jury found that the plaintiff's reliance either did not rely on any misrepresentation or were not reasonable in doing so. The contract claim has a similar, there still has to, even though the word is not reliance, there still has to be some causation on the part of the defendants in causing any harm. And in this case, the plaintiffs were not unsophisticated buyers. These were not first-time homeowners. They were, in fact, this I believe was their third property they had purchased. They bought it apparently with the intent to rent it out week by week, because they signed a listing agreement with a local realtor to do just that. They specifically hired an attorney and their own real estate broker for the purposes of the sale. And the reason that they hired the attorney, they testified, was because they had heard about real estate scams on the Cape, and they wanted an attorney to protect them. And so they hired this attorney who failed to review the master deed, failed to failed then to highlight to the plaintiffs the fact that this was a motel condominium use rather than a residential use. And thus they went ahead. And so the jury could well have concluded that if the defendants had done something improper by not affirmatively verbally disclosing that these were motel condominiums, that the defendants were not the cause of the harm, that the cause of the harm was the plaintiff's own failure to read the documents and also their attorney's failure to inform them of the true nature of the use of the property.
That said, the language in the unit deed to which your brother refers contained an incorrect statement, right? That was absolutely at odds with the permitted use of the property.
Yes, I mean, that is true, and the defendants have never said otherwise. This was the Old Wharf Village. This project was Old Wharf Village's first development project ever. These were not experienced developers, and they at the beginning used a local real estate attorney, gave them a blank template that had the correct use language in it, gave the attorney the blank template for the sale of unit deeds with this correct use language. Somehow, between giving of the blank template to the real estate attorney and the real estate attorney providing the actual unit deeds, the use language changed.
Does that give them an opportunity for a contribution through malpractice rather than a defense against liability?
Yes, suit was brought against their real estate attorney, and she settled.
Well, I guess I'm just asking if I engage in actionable conduct because the attorney I hire doesn't protect me in the manner I expect, that I'm not insulated from liability by my attorney's malpractice. I can be held liable, but then recover from my attorney.
Yes, unfortunately, there was actually a suit was brought against. I was not original counsel.
Well, you're saying suit was brought, but that's the passive voice. It wasn't your clients who brought that suit. It was the plaintiffs or unit buyers, right?
No, there was actually also another suit brought by the defendants against their own real estate attorney for failure for the use language in the deed. And that case also settled in Barnstable District Court long after the year after the trial. I'm sorry, I wasn't sure if.
I don't, you answered my question.
How does the deed get fixed?
How did the deed get fixed, or how does it get fixed?
How does it get fixed? I mean, if it got fixed, that's great, but how does it get fixed?
It did not get fixed. The plaintiffs have never asked. I would think that the defendants would certainly give them a new deed with the correct use language in it.
Well, yeah, but I mean, you know, presumably they wanted, their claim is that they thought they were buying a unit that they could reside in, and they're looking for the benefit of that bargain.
Right, and that they're wrong, that the use language is really just, of course, you know, all deeds for condominium units have to have use description in the deed, the statutory requirement. And we argue that that it is just a description, that it does not amount to an express warranty that this is in fact what we're buying, and in fact it is simply a recording of what they are supposed to be buying. The fact is that the defendants cannot sell what they do not own. The defendants had no right to sell them a residential condominium, so they couldn't. So even if they wanted to, they couldn't sell them. They couldn't sell them that, couldn't provide them that. And what the plaintiffs are essentially arguing is kind of a gotcha moment. Because of your mistake, we should take unfair advantage of that, even though we knew all along, and that, or should have known all along, that the use of this property was in fact motel condominium as opposed to residential. The plaintiffs also argue that the correct use language on the deed creates an encumbrance, but it does not meet the definition of encumbrance because it's not something that was created by the defendants. It was the town that said this property must be used in this way.
I don't really get that though, because the master deed, which I understand your clients created,
yes,
says it can only be used as a condominium motel. And that's an encumbrance they created, that even if tomorrow the town decided, you can do whatever you want with this property, it'd still be bound by the master deed that your clients created as an encumbrance, saying that it can't be used as anything but a motel. Why am I wrong on that?
Because the master deed only describes the use the way it does. Actually, I think what the master deed says is the use of the property is to be in accordance with special permits number, the ones applicable to this property issued by the town.
What it says is all the units are intended to be used as condominium motel in accordance with the bylaws of the condominium trust, with all applicable codes, laws, and regulations, and specifically with the following as may be amended or modified from time to time. And then it goes into I assume, is a special permit.
Yes, so I believe it is that way because that's what the special permits said at the time. If they, the property owners are trying to comply with the special permits. If the special permits were to change and suddenly say now it's commercial use or now it's residential only, I imagine that the defendants would have to amend the master deed to reflect that. So the final issue that I wanted to address was the issue of the jury instruction on the breach of contract claim. The confusion that was created by the issue that the plaintiffs are complaining about is actually a challenge of their own making. So in the original jury instruction that they requested language about the exculpatory clause in the breach of contract claim. They never changed that argument, that request to say the exculpatory language should be addressed separately. I'm sorry, is there a question?
No.
And addressed separately. And in fact, in the sidebar conference and in their request to reform and supplement the jury instructions, the focus of all of that was not on the exculpatory clause, but actually on the whether or not the deed created an encumbrance or an express warranty. They never addressed specifically whether, again, the fact that the exculpatory clause could not be used as a defense to breach of contract. And because they did not properly preserve the objection, and the court should find it waived. And finally, as to the testimony of other witnesses, the plaintiffs did not lay a proper foundation for the testimony of those witnesses to come in. They didn't have own property can testify to the value of a property, but only where they can lay the foundation that they are familiar with its characteristics and the nature of the property, which the plaintiffs did not do at trial. And so there was no reason to do it. The other issue was that they wanted to prove that these statements had the capacity to deceive, but Charles Edgar had already testified that he did not verbally disclose affirmatively that these were not residential units. There was no need for that testimony. And in fact, the jury actually found that there were, that Old Wharf Village did make misrepresentations about the use of the property. And so clearly that testimony was good. Whether or not having the other unit owners testify that they wouldn't have bought the property if they had known is totally speculative, because in fact they did buy the property. And in fact, all of the deeds except for the first two had the correct use language in them. So those owners have no reason to argue that they did not know the true nature of the property. I see that my time is expiring.
Thank you. Thank you both. That concludes the argument in this case. We will be in recess. The case is submitted.
Thank you.